Hi, and welcome to today's webinar entitled Updates on FSMA Legal Research Efforts. We are actually re-recording the original webinar that was aired on April 18th had some technical difficulties, and so we are re-recording the webinar today, May 15th. And because of that, we are not going to be joined by some of our presenters, but we'd like to acknowledge Chris Callahan, who's the director of NECAFS, and then two student clinicians from the Center for Agriculture and Food Systems at Vermont Law School, Sedona Chavez and Bethany Town, who did a majority of the research that will be presented on today. My name is Elizabeth Newbold, and I'm the Assistant Director of the Northeast Center to Advance Food Safety, or NECAFS. And I'm joined today by Sophia Krasinski, who's the Clinic Director at the Center for Ag and Food Systems at Vermont Law School, or CAFS, also known as. And so today, what I'd like to do is first introduce this project to you. The title of the project is Extension Legal Services Initiative, and it's funded through the National Ag Library, part of the USDA. And this is a 2-year project which initially launched in September of 2018 and will run through August of 2020. And in the first year, the efforts are focused on defining legal questions and conducting legal research. And the first year's efforts are going to be led by Vermont Law School, with the legal research being conducted by the student clinicians at the Center for Ag and Food Systems. And in the second year, the efforts, which will be focused on educational material development and outreach around research findings, will be led by NECAFS, and the educational material developed will be distributed through our communication channels and posted on the Clearinghouse. And the goal of this project is to frame and form common FSMA produce safety rule questions to be clarified through legal research, and will extend that knowledge and those project results through education and outreach. So what's the motivation for this project? Well, FSMA produce safety rule has a significant development related to the world of produce safety, and project partners realized that there was a need to explore some of these common legal questions and concerns that we were hearing across the nation on a pretty regular basis. And so what we did was we conducted a national survey in the start of this project in September, and it was open through November of 2018. And the goal of this survey was to capture an accurate understanding of these common questions and ensure that we had representation from across the nation and across the industry. And then these responses were used as the primary source of information to form and prioritize the questions that are being researched and some of the questions you'll hear about in this recording today. And then I just want to point out that this research that is being done is grounded in existing case law, statutory law, and other similar regulatory schemes. This project is not serving to define or interpret the produce safety rule in any way, and it is not serving as the authority on this topic, and it is not intended to provide legal advice. The FDA serves as the authority, as does the state regulatory bodies. And so what this project is doing is looking to case law or other statutory regulatory themes in order to provide guidance and an insight into the legal questions that have been identified by this project. And so as I mentioned, the first thing that we did was distribute a national survey, and so I'll quickly run through the summary of that survey data. This is a graph that represents where the answers were submitted from across the region. So you can see that we had good national representation. We had a total of 89 responses, 13 out of the Western region, 42 in the North Central region, 27 in the Northeast, 7 in the Southern region, and then 1 from a non-US state. The next slide you're looking at shows a pie chart that illustrates the role that the respondent falls into within the produce safety community. And so you can see here with the largest blue slice of the pie at 42% is actually grower respondents, followed by educators in the orange, and the gray is regulator. And we were pretty happy to see that the majority of the respondents did come from growers. So the responses that we used in order to form the information was based largely from input from the growing community. So after we received all of this fantastic feedback from our survey, we got together with the advisory group for this project and spent a couple of days actually going through a process of developing the questions. And the way that this was done was all of those responses from the survey were coded into central related concepts, and the goal of this was to allow for common themes to emerge during analysis. And after the coding of these responses was completed, there were 11 common themes that emerged, and all of the responses were then categorized under a theme that best illustrated what the response was articulating. Following that, there were 3 individuals who separately coded this in order to address any potential bias. And then the advisory group reviewed these themes and summarized and articulated the questions based on those specifics identified in the responses from the survey. And following that, the advisory group then prioritized the questions based on their own personal knowledge and looking at the number of survey responses that fell within each of those central concepts and themes. Okay, and from here, I'm going to turn it over to Sophia to follow up on how the clinic then took this information from the advisory group and moved forward with the research and prioritization of the questions.
Thanks, Elizabeth. So this is Sophia Kruszewski. I'm the clinic director at Vermont Law School's Center for Ag and Food Systems. And as Elizabeth mentioned, these are the priority research questions that came through the survey, through our advisory group, and they touch on a wide range of topics, from liability, so the civil and criminal liability consequences for the different players involved in produce production and marketing, and how FSMA impacts that liability. Business structure and operation, so how do business and operational structure impact compliance under the produce safety rule? Questions of insurance, how do FSMA requirements interact with product liability insurance coverage? Questions related to exemptions and qualified exemptions, so trying to understand the legal and practical implications of an exemption or a qualified exemption. Questions relating to the legal implications of or differences between a food safety audit and a FSMA inspection. Questions about produce safety rule enforcement and how implementation addresses issues of non-compliance and enforcement, including appeals, and how that might vary based on the enforcer, whether it's the FDA, the state, for farms that cross state lines. Questions about the interaction between the produce safety rule and other state laws, particularly environmental compliance issues, and how growers should plan to handle potential overlaps or conflicts between the produce safety rule and state law. Questions about how entities might prove that the variance or alternative they're using provides the same level of public health protection as what FSMA requires. Questions around the obligations of qualified exempt farms selling to facilities that are subject to the Preventive Controls Rules Supplier Verification Program. Questions about the federal policy process in general, so a desire to have a better understanding of where FSMA comes from, what FDA's rulemaking process is, and the relationship between and use of different tools like statutory language, regulatory requirements, FDA guidance documents, etc. And then some very discrete questions related to privacy and the Technical Assistance Network responses, and trying to understand why responses through the Technical Assistance Network, or TAN, have to be kept private. And so many of these questions had overlapping components, and some of them contained elements that we can't really answer until inspections begin, or aspects of the rules that are still pending or resolved. But because this is a 2-year project, we decided to start working on some of the questions that we felt we could answer more immediately, or where we could look to other more established federal statutes to draw out themes that may be common across different regulatory frameworks, and then work through some of the others over the course of the next year or so. And so the first 2 topics that I mentioned related to liability and business structure are what we'll be sharing some preliminary research findings from with you today. And as Elizabeth mentioned, originally these presentations were given by Sedona Chavez and Bethany Town, who were student clinicians in the Food and Agriculture Clinic. based on their research over the last semester. So we're re-recording this webinar after the semester has ended, so I'm going to be presenting their material today. But before I begin, I just want to stress again that the information that we're providing today is not legal advice and is intended for educational purposes only. But we're very eager to receive your questions and feedback on how to translate this information into accessible educational resources and additional scenarios to help us apply this analysis and illustrate possible outcomes. But again, we will not be providing any legal advice on a per operation basis through this particular forum. And so with that, we will begin with liability. This presentation is structured into 6 components. First, we'll lay out the question that we researched surrounding civil and criminal liability in foodborne illness outbreak cases that resulted from contaminated produce. Then I'll describe the difference between criminal and civil liability. Then I'll describe our research findings around civil liability. And then I will show you a sample of the civil liability state matrix that Sedona created that illustrates how liability law varies by state. And then I'll describe our research and findings surrounding criminal liability, and then briefly talk about why and how parties throughout the chain of produce production and distribution should mitigate the chances of being held liable for a foodborne illness outbreak. And so our research focused on answering the following question here on the screen. When a foodborne illness outbreak occurs as a result of contaminated produce, what are the civil and criminal liability consequences for the different players involved in the chain of produce production and distribution? And how does the Food Safety Modernization Act Produce Safety Rule, or PSR, impact liability? Before I get into FSMA, I want to briefly explain the difference between civil and criminal liability. Criminal liability actions are brought by the government for a violation of an established statute. The state can impose monetary fines or penalties and incarceration to hold a person accountable for the crime they committed. In comparison, in civil liability cases, the plaintiff is an individual who has been harmed by another, and the damages are determined by the court and are paid by the liable defendant to the injured plaintiff if the plaintiff wins the lawsuit. To understand how civil liability plays out in the produce arena, we first look to product liability law generally, because foodborne illnesses stem from defective food products, which fit into product liability law. And then we researched which causes of action or types of legal claims were used most frequently in civil foodborne illness cases, and which of those claims could be brought in each state. Some states had unique causes of action used in foodborne illness cases, which are highlighted in the matrix I mentioned. We also looked into the main defenses used in foodborne illness cases and which ones were allowed in each state. With regards to civil liability in foodborne illness outbreaks, we found that the most commonly used causes of action are negligence, negligence per se, strict liability, and breach of warranty. We don't have time to go into the details of each cause of action now, but generally these causes of action may be brought against many players in the chain of produce production and distribution, including on-farm auditors, farmers, distributors, retailers, and restaurants. The most common defenses used in civil foodborne illness cases are comparative fault or contributory negligence, compliance with a relevant statute, regulation, mandate, or code, the innocent seller defense, and contribution and indemnification. These defenses are important because they can help mitigate the liability or financial responsibility of a player in the chain of produce production and distribution who is facing a lawsuit for a foodborne illness outbreak. Generally, the Food Safety Modernization Act Produce Safety Rule doesn't change civil liability related to foodborne illnesses, except in a few particular instances. They are: failure to comply with Food Safety Modernization Act can be used to establish negligence per se, which essentially makes it easier for a plaintiff to establish that a defendant was negligent. And compliance with the Food Safety Modernization Act can be used as a defense against some of the previously mentioned civil product liability claims related to foodborne illness. If successful, this defense could establish that the defendant was not negligent and/or the product was not defective. These next 3 slides are examples from the state matrix, which lay out the civil causes of action and defenses and where they are available per state. Many states didn't have much information publicly available regarding foodborne illnesses derived from produce. And our research did indicate that many civil foodborne illness cases are settled outside of court, which may account for the lack of information available in some states. So this first slide shows the description and key for the state matrix table. The second slide shows a portion of the matrix substance. The states are listed on the left and the causes of action and defenses across the top. The corresponding cells indicate what actions and defenses are available in each state. Finally, the third slide shows the citations to cases brought in the state or to state statutes for each assertion made in the table. For researching criminal liability for foodborne illness outbreaks, we focused on cases brought under Section 331A of the Food, Drug, and Cosmetic Act, which generally prohibits the introduction or delivery of adulterated food into interstate commerce. Based on our research, there are few cases that assert a violation of the Food, Drug, and Cosmetic Act generally for a foodborne illness, and only one related to contaminated produce. There are no criminal cases asserting violations of the produce safety rule to date. We should note that we only researched federal criminal liability, and so we did not get into any state variations that may exist in criminal liability. As I mentioned, there have been few criminal cases involving contaminated food or dietary supplements under Section 331A of the Food, Drug, and Cosmetic Act. So we're going to focus on just two of those right now, which you may be familiar with, the Jensen Farms case and the Peanut Corporation of America case. The Jensen Farms case involved contaminated cantaloupe that resulted in 33 confirmed deaths throughout the country. The penalties for each brother in the farming operation was a $150,000 fine, 6 months house arrest, and 5 years of probation. The Peanut Corporation of America case involved salmonella-positive peanut products. These contaminated peanut products likely resulted in 9 deaths, according to the CDC's estimation. The corporation's officials were sentenced to prison for timeframes ranging from 36 months to 28 years. Clearly, the Peanut Corporation of America officials received more severe penalties in comparison to Jensen Farms, even though their contaminated food product resulted in fewer deaths that were not confirmed. This is likely because the corporation knowingly introduced contaminated or potentially contaminated food into interstate commerce. In this case, the officials sent out the peanut products before receiving lab results back. And when they did get lab results back stating that the peanut products were salmonella positive, they tried to falsify those records. In comparison, Jensen Farms did not knowingly or misleadingly distribute contaminated cantaloupe into commerce. And while intent is not a part of the criminal liability statute, that is, it doesn't matter if you intended to introduce contaminated products into the food supply, only that you did it, it can still impact the extent of the penalties that a court may then fine for you if you are found to be in violation. And so criminal enforcement actions for violations of the produce safety rule could be similar to those under Section 331A of the Food, Drug, and Cosmetic Act, because FSMA is an amendment to the Food, Drug, and Cosmetic Act, and the same penalties are allowable by statute. However, it seems unlikely that minor violations of the produce safety rule would result in criminal enforcement actions. This is because the FDA has discretion when it comes to pursuing criminal actions against Food, Drug, and Cosmetic Act violators, and evidenced by the fact that only a few cases have been brought against food producers under the Food, Drug, and Cosmetic Act to date. In addition, compliance with the produce safety rule could help mitigate criminal liability under a general Section 331A violation claim, because compliance could be used to show that the grower took all possible measures to prevent contamination, resulting in less severe penalties. Our research reinforces the point that even though many cases are settled out of court or might not rise to the level of FDA criminal liability enforcement, all players in the chain of produce production and distribution should try to mitigate the risk of foodborne illnesses and being held liable for foodborne illness. Not only will this benefit overall public health, but also it will financially benefit the player's operation in the long run and build consumer trust and help maintain the company's reputation. Players in the chain of produce production and distribution can mitigate these risks by complying with food safety protocols, statutes, and regulations, including the produce safety rule, by making sanitation and cleanliness top priority, by keeping consistent and detailed records, and potentially purchasing insurance to cover losses in the face of a foodborne illness outbreak. We know this is a heavy topic, and we look forward to your feedback on how to take this research and turn it into usable and accessible educational resources. And now I'm going to move into a presentation about how business structure and operation can influence the produce safety rule or preventive controls rule applicability. And so this presentation is based on research conducted by Food and Ag Clinic student clinician Bethany Town. And throughout this presentation, the produce safety rule is referred to as the PSR and the preventive controls rule as the PCR. So first, through the presentation, we'll look at how a business entity type may influence whether that business is considered exempt from the rules or covered by the rules, but qualified exempt. Then we'll look at how an operation conducts its business can influence which rule it must follow. And finally, we'll look at how the ownership of produce along the production chain can impact who is a qualified end user for purposes of determining a qualified exemption. This slide provides a list of legal business entities commonly available to farmers. This information is helpful and as a foundational information to determine how any of these entities may or may not influence applicability of the rules. This next slide lays out the basics of how to determine when a farm is exempt or covered but qualified exempt. This background knowledge is necessary to analyze how the rules influence a business under these criteria. And so this research really turned to the question of how the entity type may influence exemptions or qualified exemptions. And ultimately, we found that the entity type matters very little. The deciding factor in determining exempt or qualified exempt status are the sales claimed by business. A sole proprietor could have high sales, an LLC might have low sales. If the sole proprietor exceeds the $25,000 produce sales exemption threshold, then that business would be subject to the produce safety rule, either with or without a qualified exemption, which is also determined by sales. On the other hand, an LLC could make very little. And if they were under the $25,000 produce sales, then they could be exempt. So the next question we wanted to answer within this research, and under the topic of business entities, was when sales from multiple business entities can be counted as part of one farm operation. Or what if you divide a business into multiple entities so that you have two exempt or qualified exempt operations instead of one large operation subject to the full force of the rule? We also received the question, what if you have two operations but they're located on the same farm? The key to answering these questions is understanding key terms in the farm definition and what they mean to the agency and to the courts. The important key terms I focused on come from FDA's definition of a farm as including an operation under one management. So FDA's farm definition is quite long, but the key term that we focused on were an operation under one management. The FDA and industry guidance didn't elaborate on what these terms mean, but explained that the agency will look at the individual situation and make a decision about when a farm with multiple business entities is a single operation under one management on a case-by-case basis. The courts are also silent on the matter, mostly because they've not had opportunities to rule on these terms, given that FSMA is such a young statute and the rules are just coming under enforcement. We had to dig a bit deeper then, and it was suggested that we look at analogous case law from litigation under the Fair Labor Standards Act, whose definitions include an enterprise under common control, which is close to an operation under one management. We found one helpful case where the court evaluates when a business is an enterprise subject to the Fair Labor Standards Act and explains that an enterprise demonstrates common control where the performance of the described activities is controlled by one person or by a number of persons, corporations, or other organizational units acting together. The court found common control existed because one person oversaw operations of sister companies. Though another person managed the financials of one of the businesses and they were registered as separate entities, the court found common control because they shared operational management, phone services, and a scheduler. The court further explained that in analyzing whether there is an enterprise, it is ill-advised to rely on formal corporate structure while ignoring the practical operation. In another Fair Labor Standards Act case, the court actually uses the term under one management to describe what an enterprise looks like. In this case, the court needed to decide whether a liquor department housed within a drugstore was separate from the drugstore portion of the business. The lower court said yes, because the state liquor department set the price and maintained oversight of the product. The circuit court reversed, finding that the business was one because it shared employees, a retail space, parking space, and management. I want to reiterate that these cases are interpreting a totally different statute enforced by a different federal agency, so they aren't binding in terms of how a court may interpret the terms and definitions in FSMA. However, these cases signal that what matters most when deciding if there are multiple businesses or not is not necessarily that they are distinct legal entities, but rather what the activities of those businesses and the logistics of the daily operations are. We intend to conduct more research into other potentially analogous regulations to further build out this analysis. But based on our current research, this slide provides a brief list of the scenarios that we use to further apply this analysis. We evaluated the situation of an older and younger generation operating different businesses on the same farm, an owner that divides a farm operation into different entities, and how to handle situations when components of a business are owned by different entities, like in a landlord-tenant situation. Ultimately, each analysis focuses around who is doing the work and how inseparable the operations are. The next aspect of this research looked at how operational structure impacts which rule applies. Definitionally speaking, if the operation is a farm, it would follow the produce safety rule. If it's a facility, it would follow the preventive controls rule. However, what the operation is doing matters, just like in the preceding portion of our research. The first thing a business must do to determine which rule it must follow is determine if it's a farm or a facility. These are important because the rules carry with them different requirements, and this slide contains a summary of the FDA definitions. We again use scenarios in our research to analyze how the distinctions between operations matter. A few common scenarios are whether an operation is a secondary activities farm or a facility, how the rules may apply to auction houses, and when market intermediaries like food hubs or brokers may need to register as a facility and follow the preventive controls rule. Not only does our research look to whether market intermediaries themselves need to register, but also how these intermediary services may impact whether a farm is making sales to a qualified end user for purposes of determining if the farm is qualified exempt. To explain when a market intermediary may influence a farm's sales to qualified end users, it's important to consider first whether the market intermediary is a retail food establishment, as then the intermediary itself is considered a qualified end user. If not, whether the market intermediary assumes ownership of produce and redistributes, processes, or otherwise handles the produce as a facility would. Again, this is an analysis that requires a look at the activities, how long, again, this is analysis that requires a look at the activities, whether the intermediary is holding product or not to determine whether the sales are to a qualified end user. To conclude, there are some overall important factors to take away from this research. First, the definitions matter, and you should look there first to get a sense of where you fall within FDA's definition of a farm versus a facility. Second, consider the activities of the agricultural business. The activities are more important than how a business is registered as an entity. Using entity formation to appear as though there's more than one operation is unlikely to prevail over an agency or court review when the operations appear too closely related in purpose and practical activity. However, there may be cases where a court will agree that splitting entities was appropriate given the details of the situation. So consider the whole picture. If a business wants to divide, consider the benefits and pitfalls of managing multiple entities, even when they can be practically divided enough to establish separate operations. Look at all factors. For example, taxes, estate planning, registration fees and requirements, instead of relying on any one issue in making that decision. And that concludes the presentation. I'll turn it back over to you now, Elizabeth.
Great, thanks, Sophia. Thank you again for viewing this re-recording of our webinar. And as Sophia mentioned, this is an ongoing project and we are always interested in hearing your feedback, especially around how this information might be most effectively used by service providers. So whether that be through fact sheets or webinars or other forms of educational materials, we are eager to hear what that would look like and how that might be best used. And so we'll be providing a link to the survey that you could take and provide that feedback to us on the NECAF's website along with this webinar so that we can continually receive your feedback and help to serve your audience as best as possible. So thank you again and have a great day.